Good morning, and welcome to Mulcahy Law Firm's third Facebook Live regarding your questions pertaining to the COVID-19 crisis and HOAs and condominiums in Arizona. Over the past few weeks, we've received a lot of different questions from property managers, board members, owners, and associations regarding how the pandemic is affecting them. And we found it to be really useful to provide the Facebook Live services so that we can answer a lot of these questions and get the word out there so that all of you can be making good decisions regarding your association. Today we have several questions that have already been submitted prior to the Facebook Live. And so we're going to start out with the three general subjects first and then go into the individual questions. So the first question is, what are some tips for legally conducting a virtual board meeting, annual meeting, and special meeting of the membership during the COVID-19 pandemic? This is a really timely question because right about now, all of us are just getting ready to conduct our regular board meetings for April. And maybe some of you had to cancel your annual meeting or special meeting of your membership in March due to the stay-at-home orders or other things that may have come up pursuant to COVID-19. And so what we'd like to do is just start out by talking about how the pandemic has changed how we conduct our meetings. As many of you know, we used to conduct our board meetings in person and our annual meetings and special meetings of the membership in person. And right now, since the governor has issued the stay-at-home orders and since we are supposed to be social distancing pursuant to those orders and other county requirements, it's our opinion that boards should not be meeting in person at this time. And so how can Arizona associations balance the requirements of the open meeting law and also still, comply with the governor's orders and the county's requirements regarding social distancing? It's a balancing act for sure. But what we'd like to do today is give you some tips so that your board can continue to do business while the pandemic is ongoing and still comply with Arizona law so that you aren't going to be involved in any lawsuits for any of the decisions that you've made during the pandemic. And so I'd like to just start out by saying over the past few weeks, our firm has assisted a number of associations on running either teleconference calls or conference calls to help them conduct their business. And I would say that probably 95% of those calls have been really productive. And associations have been able to continue on with their business. And one kind of really interesting part of the new law is, or of the new situation that we're in, is that a lot of these board meetings and annual meetings are significantly faster than they would be if you were doing them in person. So I'm a silver linings type of person. So one of the silver linings of the COVID-19 pandemic very well could be that we are having significantly shorter meetings and accomplishing more business while we're having these teleconference meetings or actual conference call meetings. And just so as a baseline, let's talk about what is teleconferencing. The system that our firm has been using significantly over the past 4 weeks is a system called Zoom. And Zoom is a system where you have either a laptop, a computer tablet, or a smartphone, and you dial into the Zoom app. And during the teleconference meeting, everybody who has dialed in can see each other and hear each other. And we found that the Zoom application has been wonderful to use for many of our clients. I know that about 2 weeks ago, there was some negative press regarding the Zoom app and some privacy issues that people were being hacked into. But I've received assurances from Zoom that that situation has been corrected and that if you update your app, if you downloaded the app several weeks ago, if you update your app, now the conference calls will require a password and that there haven't been any more instances of that since about the first occurrence that happened about 2 weeks ago. So Zoom is an excellent system. We've been using it. We feel that it's easy to use, and we felt that the boards have been able to use it effectively to do their business. Our firm has been helping HOAs and condos to set up, organize, and troubleshoot these Zoom meetings. So please keep us in mind if you need any help with organizing a teleconference meeting for your association. We're here and we're happy to help. What I can tell you from being in the trenches, the Zoom trenches, is that many associations, the first time that they use Zoom, it's different. And so anytime you do something that's different or new, sometimes there are some challenges that you need to overcome. I would say that 85 to 90% of the people can just use an instruction sheet that our firm provides, and you're welcome to contact us to obtain that for your residents. And they can just use that instruction sheet, and they can, what they can do is they can dial in and they have no trouble. But we've noticed that the first time we do the dial-in, that occasionally there are some people that have difficulty. And so what we suggest is that you have a troubleshooter and have a place where somebody who's having difficulty joining a teleconference to be able to call and get assistance right away, kind of like a hotline. And our firm's been helping with that too. We have one person on our team who's the designated hotline whenever we're having a Zoom call for a board meeting or an annual meeting or a special meeting of the membership. And we just walk the person through step by step, and after we have that the call with them, everybody's connected. We haven't had any calls so far where somebody has not been able to do it. So we would suggest that you do that. Okay, so what are some tips that we can give you so that you still comply with Arizona law and are able to still comply with the law even though the pandemic is ongoing? So let's start out first with the notice requirements under the Arizona open meeting law. Associations still have to provide notice to the members at least 48 hours in advance of the meeting. And so that requirement is something obviously that cannot not be followed. It needs to be followed. And what many associations are doing is in the notice, they have the date, the time, and a statement that due to the pandemic, we are now conducting our regular board meeting, our annual meeting, our special meeting via teleconference. And then also include with that notice specific instructions that can be used for that person to dial into the conference call. I noticed something kind of fun that my children are now e-learning, and they had kind of some suggestions on, what people should and shouldn't do during teleconferencing. And we've added those now to our suggestions on teleconferencing. And I mean, obviously the ones for the kids are kind of funny. It's things along the line as you can't teleconference in from bed and you can't be in your pajamas. The ones for the associations are a little bit different. We're not going to have any attire restrictions, but something that we would want to put in there is that, there can't be interruptions of the board during the board meeting. And I'll talk a little bit about how we can control that. And that also that people should be keeping their device on mute while the meeting is being conducted so that there's no background noise. Just so you know, there is an override by whoever is the organizer for the meeting. And interestingly, the organizer for the meeting, which in many cases has been our firm, in some cases the management company if they're conducting the meeting by teleconference, they can automatically mute somebody if they're not following directions. So that's kind of a nifty little thing that the Zoom teleconferencing is allowing us to do to keep control of the meeting. So remember that we have to give the notice. All members are still allowed to participate in the meeting. And that's what the law says in Arizona. And so they can participate during appropriate times or before the board takes formal action on something. And so what we're suggesting to our boards when they're conducting a virtual teleconference board meeting is that you still have your regular owner forum at the beginning of the meeting. And then when you go into the meeting, you mute all the non-board members so that they won't be contributing or interrupting business. And, then the board conducts business. If an owner wants to provide some sort of feedback, or they want to, before the board takes formal action, comment on something, which they are allowed to do under the law, there's a feature on Zoom where they can raise their hand. And whoever the organizer of the call is, they need to be watching for that. And if it's an appropriate time where the homeowner is allowed to speak, typically that would be before the board takes formal action, so before the board votes on something. Then they can turn off the mute button. The organizer can turn off the mute button, allow the person to ask their question. And then, the board can either answer or respond or just say thank you for your response. Now, sometimes you get people who are a little bit lengthy in their discussion items, the homeowners are. And if you don't want to have your meeting hijacked by that, there's also another feature on Zoom that you can use. And that would be that you would allow them to ask their question electronically. So it's almost like a text on the Zoom system. The owner can just write down their question, and then the board can stop and answer that question. And that's also a really good strategy to keep your meeting moving along. Or if a lot of people have comments, you can sift through the comments quickly and you won't have duplicative questions. You can answer, 5 people ask the same question. You can answer that question just with one response. So I think that's really a good tip. Another suggestion is regarding the agenda. Remember that under Arizona law, we are required to provide an agenda to the members. And what we've been suggesting since there was a new law passed several years ago, indicating that the meeting topics that were going to be discussed at that meeting needed to be provided to owners, at the time the notice of the meeting was sent out. So for several years now, we've been suggesting that associations also post the agenda when they post the meeting notice. Another feature and we continue to suggest this even with the teleconference meetings that we're now doing. Another suggestion is the meeting organizer at the start of the Zoom call. What they can do is they can place on the screen, the Zoom screen that everybody is participating in the meeting, a copy of the agenda. So everybody has it handy right in front of them. And that's kind of just a neat feature that you can use when you're using Zoom. Because then everybody will have it at their fingertips. Maybe they didn't take a picture of it if your meeting notice was posted with the agenda on the common areas. Maybe they didn't get a copy of it. And so it's nice just to have it handy. And we would suggest that boards as best practice do that in your virtual meetings. What if somebody doesn't have the technology to attend? We're starting to see that, or maybe some people are going into shutdown. They don't want to attend a meeting via Zoom. They want to do it the old way. Here's what we are suggesting. A couple of great things that you can think about doing would be, number one, we don't suggest meeting in person during the pandemic. And I think you need to be firm on this. And I think if you go back to our first Facebook Live where I talked about boards needing to exercise leadership, this is one of those times. There will be people that will not be happy about the changes in technology. And they will still insist that the meetings be canceled, or that, we still allow to have 5 people in the room with 10 feet, between them. We don't recommend that. And I want you to know that that is not a best practice in our opinion. We think that you should be converting now to the virtual meeting using teleconferencing or using a conference call. In terms of what if somebody doesn't have the technology to attend, as I said before, some suggestions that we have would be that the Zoom meeting can be taped. And we would encourage boards to do that, use that feature. And when the person is setting up the Zoom meeting, the organizer, there's just a box that you click that indicates that the meeting's being taped. And so if somebody can't attend live because of technology issues, we can email them the video of the meeting. And they can watch it then, shortly after the meeting has taken place. Another suggestion would be to get meeting minutes out of the meeting that you've handled virtually as soon as possible. If your board hasn't approved them yet, which is likely going to be the case, you could just say that they are the draft minutes for your association, and to send them out as draft minutes with a notation that the minutes could be changed once the board does a final approval of the minutes. So those are some suggestions for associations conducting virtual meetings, especially suggestions for people that might not be adapting to our new normal with the pandemic and want us to continue to do business the way that we used to do it. Okay, let's switch gears and talk a little bit about emergency rules and enacting emergency rules. A very common question that we've been getting is, does the board have the right to enact emergency rules? And along that line would be, what about short-term rentals? What if we want to enact short-term rental emergency rules? Can we do that? How do we do that? And so emergency rules are typically adopted by the board to address an imminent safety threat or a substantial economic loss. And I think we can all agree that the circumstances that we are in right now with COVID-19 clearly fall into those two categories of an imminent safety threat and, potentially substantial economic loss to our associations. And how do you adopt emergency rules? They're adopted by the board at an open board meeting typically. Or in some cases, if you can't wait to notice a board meeting, wait 48 hours to notice it, some boards are taking emergency action via email under the emergency meetings exception. And then at the next regular board meeting, they're reading into the record and providing the emails as, a record of what was transpired. And so what are some things that we're seeing emergency rules being used for? Closing common areas, dealing with essential versus non-essential access requests, making emergency rules on construction in your association, who is or is not allowed to enter a high-rise condominium building. Assessment issues, short-term rentals. These are all very common things that we're seeing right now during the pandemic of boards adopting emergency rules. Some examples that I can give you, here on this call that I think might be able to help your association. If you're concerned about short-term rentals in your association, maybe the concern is that renters from hotbed areas want to come to your association and rent, and you're concerned that that is going to cause a spread in your association. And I have one association where this specifically happened. We were notified that somebody from New York City was coming to a high-rise, and it was a large concern for the residents in the association, in the high-rise, for the board, and of course for the on-site manager. And so, we've enacted a number of different restrictions. We have to look at the facts on a case-by-case basis. And so if your association is in need of adopting emergency rules, please reach out to our firm. We were able to craft emergency rules that were a win-win for that high-rise. And what we ultimately ended up doing was requiring the renters to self-quarantine somewhere outside of the building in Arizona for 2 weeks. And then after they provided written evidence and proof that they had self-quarantined outside of the building in Arizona, then we let them start their rental. But again, every association has different facts right now. We had another association where the association's pool was closed and by the board due to the pandemic. And we had a resident who has a disability, and he wanted a reasonable accommodation under the Fair Housing Act to still use the pool. And, that was kind of a sticky wicket because we have to be careful under the Fair Housing Act that we're not discriminating against any protected classes. And so we did have to tell that owner that unfortunately, the pandemic concerns outweighed, his rights under the Fair Housing Act. And so we're seeing all kinds of different issues that we've never seen before. I've been practicing law since 1995, so 25 years. I've never been through a pandemic situation with an association. So we are seeing new issues that we haven't seen before, and we're using our best judgment. And a lot of associations are reaching out to our law firm to ask for advice on specific circumstances that they're facing. And we're available here to help you as you navigate those difficult circumstances. Let's talk about planning ahead. I like to plan ahead for things in life. I like to plan ahead for my week, my days. I think we all in the HOA and condo industry, we need to be planning ahead for financial difficulties that are going to be facing the association as a result of COVID-19. And I've really spent a lot of time since our last Facebook Live 2 weeks ago thinking about what's the best advice? What are the suggestions that I can give associations so that your association is prepared and can minimize the financial difficulties and impact that COVID-19 is going to have on your association? And so after considerable thought, here are my suggestions. First, we need to recognize that we are in unprecedented times. I was watching the news this morning, and they announced that there have been 22 million in the United States filing for unemployment in the past month. That is just a staggering number. And so I think that we can anticipate that there are many people who have never been unemployed before who are now facing unemployment, and people are scared. We're all scared. I think we all need to admit that. Everybody has fear about the pandemic and how it's going to affect all of us in many different ways: health, financial, family, not being able to see people. And so this is a fear, and it's a fear that we need to hit head on as we do our planning for our associations. And so the first tip I'm going to give you is watch for trends. April 16th is today. Today's a really big day for associations. Why? Because this is our first cycle of assessments that have been due April 1st and that are now past due today, April 16th. And so what I'm asking for associations to do is watch for trends in payment of assessments for your owners. And I've been, getting my feelers out to management companies and association boards directly to find out, how are things going? Are people paying? Are people not paying? Are you being contacted, to let you know that they're not going to be able to pay this month's assessment? And one thing that I will say is that it's a little bit early. I talked with a management company yesterday, and they said that all their owners that pay by credit card or direct deposit, they will find out that number on the 19th of April. And, so it might be just a little bit premature to determine this. But what I'm asking you to do is look at the April numbers. See how many people have paid their assessments and how many haven't. Compare it to April 2019 and look for trends. Maybe in April 2019, when the economy was amazing, we had a 3 to 5% delinquency rate. Let's look at April 2020 and let's look for a trend. If the trend is that now we have 20, 25, 30% of your owners not paying assessments, we need to figure out what our plan is for the rest of 2020. There's some uncertainty as to how long, the current situation is going to last in our country and how long it's going to take to reopen businesses and to get back to normal. We may not get back to normal until, 2021. We don't really know the answers to that. And so what I'm asking for you to do is be agile, be ready to pivot as an association. And one way to be agile is to know what problem you're facing, okay? And so if we start to see in April that I'm anticipating somewhere between 15 and 20%, possibly as high as 30% of your owners will not pay their April assessment, what I'm asking you to do as a board is to reach out to our firm or reach out to your management company and start talking about how you're going to make up the deficit. What are you going to do as an association so that you have enough money to pay your bills? And, just as background information, remember that associations set a budget every year. So you set your budget for 2020 and you have expected income that's going to be coming to your association in the form of assessments. And if that income is reduced by 20, 30%, what cuts do we need to make so that we can still meet the most serious and the most necessary expenses for your association? And so, like I said, April 16th, big day. I'll be really interested to hear, and you're welcome to reach out to us on Facebook and let us know what the delinquencies are for your community as you get that information. Make sure, too, that you're talking to your management company before the meeting this month and asking them for this information, because typically what information you'll see at your April board meeting is the information for, last month's financials. And truly, those are important. You need to review those, but truly the most important thing that your board and your treasurer for your association and your president need to be keeping their finger on is, what's the income? What type of income issues are we going to be having going forward? And then in May, you're also going to need to be doing the same analysis. Is the trend getting better? Is the trend getting worse? And then thinking about what your pivot or your plan is so that your association does have enough money to pay for all the expenses of your association. Okay, another point that I'd like to make right now, some tips for planning ahead for financial difficulties. Remember to up the communication to your owners about the importance of paying assessments in a timely manner. Try as hard as possible to get as many people as possible on direct deposit so that they're paying their assessments automatically. Because we find that the associations that have the highest level of direct deposit assessment payments typically have the lowest number of delinquencies. Think about implementing a collection policy if you have not already implemented a collection policy for your association. We are suggesting that associations just continue with their regular collection policy at this time. There are some restrictions, which I'll talk about in a minute. But if your association typically sends out a courtesy reminder letter, once the assessment is 20 or 30 days past due, continue to do that. That's important. If your association sends, a demand letter once it's 45 days past due, continue to do that. It's important to continue to communicate with your owners and let them know that this is still a responsibility that they need to pay. We're also highly suggesting that associations who have delinquencies, that they record a lien on the owner's property for non-payment of assessments. A lien is just a placeholder, so to speak, that is recorded with the recorder's office in the county that you live in, indicating that an owner owes X amount of dollars to the association, and that property cannot be sold or the mortgage can't be refinanced without that lien being paid. So it's just a good placeholder to protect the association and also for the owner to know that this is a serious debt and that you do need to pay it. Now, whether your association is going to go forward and file a lawsuit to collect the money, I think we really need to kind of take a case-by-case basis. At this time, we're not suggesting that you foreclose on owners. We think that this is a time where we should, just put a hold on it for at least 30 to 60 days, and see how things are going, maybe at the end of May before we would ever suggest doing a foreclosure. But we are open to continuing to look for other ways to collect from owners, such as filing justice court actions or pursuing garnishment if we have information regarding the debt that they owed before the pandemic started. A couple things, just a third point I want to bring up is, kindness and compassion during this difficult time. So boards need to exercise being kind and being compassionate to owners during this difficult time. As I said, you're going to be encountering owners that have always paid their assessments before. And due to the pandemic, maybe they lost their job. And, this is a horrible time for them. And so we've been talking to a lot of debtors that have been calling our office. And, we have listened to everybody and have heard a lot of very difficult stories from homeowners. And so we're asking that the boards also, be kind in this time and recognize that a lot of these people aren't in this circumstance because of anything they did. It's just a result of COVID-19. And so along those lines, you're going to get homeowners that ask for hardship exceptions and ask for, extensions to pay, etc. And we're encouraging boards to very seriously consider and approve those hardship exceptions if owners specifically request them. And what we've seen in our office is that maybe if an owner's on a payment plan with an association, they contact us and say, hey, I can't pay it this month. Can I put this month on the tail end of the settlement agreement or the repayment plan? And we've been regularly doing that, and we think that's a good idea. If somebody calls and says, I can't pay anything, or I'm never going to be able to pay, or something along those lines, we really are trying to encourage them to pay something. Pay something as a good faith, showing that, you understand that this debt is something that you do have to pay going forward. One really encouraging thing that we've noticed this week in our firm is that a number of debtors have been contacting us. And debtors, I would mean people that aren't paying assessments to their association and have been in our office before the pandemic for non-payment of assessments. A number of debtors have been contacting us and telling us that they are using their stimulus money to pay the association, or they're using their tax refund to pay the association. And some of you may know that some of the stimulus money has already arrived in people's bank accounts. And so we're greatly encouraged by that some of the stimulus money might be helpful in helping associations to get some of this unpaid debt paid down going forward. And also some of the stimulus money might be used to pay assessments going forward for association members that may have lost a job, et cetera. So, those are all positive trends that we're seeing on our side as association legal counsel. Another program that our firm recently became aware of is through the state of Arizona. And it's a special program that helps owners who own property in the state with paying their mortgage or paying past due assessments to an association. And there is a significant amount of money in this particular fund. And we are now reaching out to owners who are in collections with our law firm to ask them to take advantage of this special state program. And it's our understanding that there is over $10 million earmarked in this program. And so I would encourage you, your association boards that are listening to this message today, to please contact our office to learn more about this program, because it might be a way to really help your association from having significant financial difficulties. And we're working on that right now very closely with owners that are delinquent to have them take advantage of this program. And the thought is that they will apply for the program, they'll be accepted, they'll receive the funds, and then they will use the funds to pay the association and their first deed of trust or mortgage company. So that's kind of an exciting program that we alone as a firm are encouraging boards that we work with to consider utilizing for the owners that are delinquent in the payment of assessments. Another question that we've been getting on financial difficulties for associations are, can we borrow money from our reserve to pay the regular expenses of our association? And, we don't encourage that, obviously. Those monies in the reserve funds are already earmarked for long-term capital expenditures. However, I can say that I have seen associations do this in the past in financial difficulties. And so, while I don't encourage it, if this is something that your association is going to be doing, I would encourage that you contact our office and we talk about what would be the proper legal procedure to do this. And again, we aren't recommending that associations do this, but if your association has no other options, this could be an option that would work. We'll also want to talk with your CPA for your association to determine if there are any special requirements that you may need to comply with from the CPA standpoint. But typically associations borrow the money from the reserve and it's documented in the minutes, and then they repay the money back to the reserve when they have the funds again. So that is a possible thing that you could do, but again, it's not something that we're encouraging. Another question that we're getting is, okay, we anticipate financial difficulties. Can we cut services at the association? Try to get out of contracts that we're in so that we don't have to pay vendors that may not be totally necessary for our association. I think we really need to carefully analyze this if your association is considering doing something like this. What we would want to do first is, are the services something that the association is required to provide to owners? And if it is, we have to look at, due to the pandemic, can we cut this because it's not something that's even available right now to use? So we've been analyzing that for a number of different associations, at this time. We've also been looking at a lot of contracts for associations, and many associations are asking, hey, can we pay a lower price on the contract because we feel that the vendor isn't providing as much service? And my initial feeling on that is likely no. The contract is a written contract. If the other party in the contract is agreeable to amending the contract, that is something that could possibly work. But we have some associations that have like a lot of extras, like maybe some of the large master plan communities have, like a plant care service. that is in the clubhouse, if they have a very large clubhouse and they've decided to discontinue doing that and the contract allows them to do that and that saves them some money. There are a number of different cost-cutting type ways that associations could save money to make up that 20 or 30% delinquency that we're anticipating in your associations. But what I would encourage you to do is, if you're going to cut services or if you're going to try to renegotiate contracts, that you please reach out to our firm to discuss it, because we want to make sure that you're making good decisions for your association if you are planning to do that. Another question that we're getting often are, what about these loans under the CARES Act? Are these something that our association should be taking advantage of? And so the different loans under the Federal CARES Act that was passed about 3 weeks ago are the PPP loan and the EIDL loan. And so just as a starting point, as of April 16th, the PPP loan does not apply to associations, and that may change, as the government evolves with different programs that are coming forward. But CAI, the Community Associations Institute, has, I believe is in agreement. They sent out a call for action recently to ask members to urge Congress to include nonprofit associations in the PPP loan. But it's my understanding and my belief that right now associations do not qualify for the PPP loan because it's not characterized as the type of organization that specifically qualifies for a PPP loan. So we're not encouraging boards at this time to apply for it. The EIDL loan is the disaster relief loan, and that allows associations to take out a loan up to $2 million at an interest rate of 2.75%. And at first glance, that looks like, oh, wow, we can get, a loan for our association for, 2.75%. That looks like a good deal. But I think associations need to be really cautious about the EIDL loan, and here's some thoughts on it. Well, first of all, you're going to have to prove that there's been economic harm to your association based upon COVID-19. And it's a little early right now to determine what that harm is. And so, if associations, it's something we should keep in our back pocket for sure as something that we might be able to use. But right now, I think it's too early to be, filing for EIDL disaster loans with the federal government right now for associations, because we really don't know the extent of the harm. We don't know how long this pandemic is going to last. And I would encourage boards to take a more cautious approach on the EIDL loans. And remember, too, that a super majority of your association documents are going to require homeowner approval before you can take out any loan. And so there needs to be, a planned process if your association is going to proceed forward with an EIDL loan. And it would require, in most cases, it's going to require a vote of the membership for you to do that. Also, kind of an interesting tidbit that I learned as I was on a large webinar for CAI National last Friday was that one of the speakers said that there may be other community association banks that will be able to give planned communities and condominiums a lower rate than the EIDL loan. So we might be seeing rates lower than the 2.75% interest. So again, another reason for us to be cautious and to wait to see if, due to your financial difficulties, if it really is necessary for your association to file for a loan or to request a loan from the federal government or a bank. Another thing to think about are business interruption claims. Many associations have insurance, or all associations should be having insurance. And you all should be reaching out to your agent right now, asking about the procedure to make a business interruption claim. And I think what you'll hear from your agent is that, well, you do have business interruption insurance under our policy, but there is a virus exemption, and so your claim will be denied if you make a claim. And what I'm suggesting to associations on this Facebook Live is that you place your insurance carrier for your association on notice of a potential business interruption claim due to the financial difficulties resulting from COVID-19. All you have to do is write a letter. If you want our firm to help you with that, please contact me and we will prepare the letter for you to send to your insurance agent. Now, why do I want you to do this? I want you to do this because there is some belief in our industry and in the insurance industry that there's going to be a federal bailout of the insurance companies on these business interruption claims. And if we don't make or put the insurance company on notice now, when we're aware that there are financial difficulties resulting from COVID-19, that will result in a business interruption claim, that we may lose our right to make that claim at a later date if the government does in fact do a bailout and require the insurance companies to provide coverage of a virus like COVID-19. And so what we're suggesting is that you put the insurance company on notice of a possible claim to protect your interest in the future in case there is that type of a government bailout. And those in the know on insurance issues have, told me that a likely outcome would be that the government would fund the payment of the business interruption claims, and then the insurance companies would act as an administrator or claims adjuster to pay out the money on the business interruption. So I just want to make sure that everybody who's listening to this Facebook Live today knows the importance of making the notice of the business interruption claim so that you're protected in the future in the event that there is some sort of a government bailout of the insurance companies on this issue. Some other things to think about, I always like to think about the future and how things could be positive for associations in the future. I think associations should really be thinking about taking advantage of some grants that different cities around Maricopa County offer to associations. We're familiar with almost every city in Maricopa County has grants for associations. And what I would suggest is that you consider reaching out now to the city that your association is located in and find out, when do those grant processes start? Some of them may reset in July, and then that money would need to be used, from July 2020 to July 2021. And typically how the grants work are that the city pays 50% and the association pays 50% on projects. Now, I don't know how COVID-19 is going to affect the city's fundings of grants. It may dry up the grant money. But I'm, just here to give you suggestions on how you might be able to utilize some city services that might help your association in times of financial difficulty. So I would encourage you, reach out to your different cities, find out when their grant programs reset for the next reset, and consider maybe taking advantage of one of those grants. And getting a capital improvement project done in your association, with the grant money that the city offers. Just kind of before I go into the questions, I would like to just say a couple things. Well, first, I want to thank the Mulcahy Law Firm team for really stepping up and doing an outstanding job for our clients and for those in our industry who are in need of practical legal advice. I'm really lucky to have such a wonderful team, and we all have been working really, really hard to provide information to the associations that we work with. So I'd like to do a shout out for them. Second, I'd like to do a shout out for the property managers who are working overtime right now, helping associations navigate all these difficult situations that are coming their way, and they're doing a great job. I've really seen our industry come together, as well as the boards. Remember, the boards are having to make all these difficult calls on closing common areas and having their meetings by virtual meetings and taking some flack from people, frankly, for having to make difficult decisions to protect the health and safety of owners. So great job, board members, for having the leadership and being able to have thick enough skin where you can make decisions to protect your neighborhoods. And last, of course, we want to thank our healthcare workers and the essential workers in Arizona who are continuing to work and providing, a service to all of us so that our lives can continue in the future and that we can help people in the future. So wanted to start out with that. Before we even started the Facebook Live today, we had somebody comment and ask a question. So the question is, can or should an HOA grant a forbearance to a homeowner for regular assessments, special assessments, fines, and fees? What questions can or can't be asked of a homeowner to determine the need for a grant or a forbearance? If you grant a forbearance to one homeowner, do you have to do it for everybody else? Really great questions. And so I'm assuming by forbearance that this person is saying, can we, tell somebody they don't have to pay? And I would be opposed to, just giving them, an unequivocal, you don't have to pay. I think that you should listen to owners that contact boards and ask for help during these difficult times. I think that you should require accountability from the owners that are asking for, maybe a month not to pay or 2 months not to pay. But I think you need to have an agreement in writing between the board and the association owner as to, what the plan is for them to pay back any months that they miss. And I wouldn't be, going any further than 1 or 2 months at this time. And, I really, just based upon the calls that we've received in our office over the past 4 weeks, we haven't received a lot of calls like this. Let's say of 100 calls that we've received from debtors regarding unpaid assessments, I would say maybe 10 have asked for, hey, we can't pay anything right now. And what we've done in those circumstances is we've either asked them to, come up with a plan, maybe in a month or 2 to get back on track, but we don't just say you don't owe anything. And, I think just kind of the follow-up to this question is, if we do it for one person, do we have to do it for all? And I would say no. But I do think that if an owner contacts you, we should be trying to work with the owner to get, a payment plan or a repayment plan down the road to repay the debt. And, can we ask for their social security number and, look at their bank statements and get a letter from their employer? Probably not. We're not doing that as a firm. What we're doing is we're listening. We're being kind and compassionate when they call. And we're trying to get an agreement in writing for them to pay the debt that works for everybody and that we know that they can follow. And so those would be my best suggestions to that question. Another question, if there are only 8 homes in an association and a common tennis, pickleball, basketball court, is there still a need to lock it and notice not to use until further notice? Really good question. So do we have to lock something? If there's only 8 people there, I think you have to look at, what's happening. Are people respecting the wishes of the board to not use the amenities? If that's the case, then, I don't think you have to put a padlock on it. I know my association where I live, they first put a sign up and then people continued to play on the tennis courts, even though the association said the tennis courts were closed. And that resulted, obviously, in a padlock being placed on the property. And so, I think we have to look at it on a case-by-case basis for each association and determine, what's working for your association. Remember, the board has the, obligation to keep your common areas safe. And if people are violating the request not to use the amenity, then you may need to take action to make sure that the property is safe. Can we simply suspend meetings if we don't have any pending issues? Yes, of course you can. So if your association is in a quiet time right now and you don't have any pending issues that you need to have a meeting to discuss something, you definitely can suspend the meeting, indefinitely. But what I would do is I would make sure that you tell your owners what's going on, why you're doing it, and that we don't have any pending issues. And if anything comes up, we will renotice meetings shortly. Just have good communication so that people don't think decisions are being made in secret or that violations of the open meeting law are ongoing. So good question. We can still conference using telephone only, or can we still conference? Of course. I have some associations that look at the Zoom teleconferencing and they just say it's not for us. We don't want to do that. And that's fine. You can use just a regular conference line. You will need to use a service because remember the owners would need to be able to dial into the conference call to listen into your board meeting. And if you need any help with that, our firm has a teleconference service. We'd be happy to help you with that if you need that. But of course, you can do your meetings by conference call if teleconferencing doesn't work for you. We have community laundry rooms, and most residents do not have washers and dryers in their homes. There is no dedicated maintenance person. What are some guidelines that we should have regarding our laundry room? Okay, that's a good question. So if you have a community laundry room and you don't have a dedicated maintenance person, I really think you should be thinking about what the protocol is for cleaning that room to make sure that there is no spread of the COVID-19 virus. And so I think your board may need to hire somebody temporarily to come in and clean every day, multiple times a day. If you're unable to do that for financial reasons, then I think that you should at least provide supplies in the laundry room for the owners to come in and, to clean it before and after they use the amenities, and make it very clear through a notice that that's what is being asked for them to use the amenity. You may also want to have some hand sanitizer in there as well, so that people can use that in addition to any bacterial wipes or antibacterial wipes. Another option, we have to look at all options here, would be to, just close the laundry room and ask them to go to a laundromat. And I'm sure your association probably won't want to do that, but I just want to mention that that is also a possible option. How about waiving non-income late fees and demand fees? Great question. So if we have an owner that can't pay assessments, can we waive late fees or, some other charges like interest, or I'm not exactly sure what she means by demand fees, but maybe like just you send out free letters as a reminder or something like that. I've always been of the opinion that if an owner is paying in full, in my opinion, it's okay to waive the late fees as an incentive to get the owner to pay in full. Now, I don't always agree that if it's like a habitual type person who never pays their assessments on time, that type of person, that's a little bit different analysis, because that person needs to know that there is a penalty for not paying assessments in a timely manner. But I think these are all great issues right now. Are we going to charge late fees on some of these owners that have contacted us asking for, a deferment for a month or two and paying our assessments, and they'll get caught up in, the next 6 months or year or whatever. I think it would be, just fine if your association decides that you're not going to charge them a late fee, but it's also okay too if you do charge it, because under the law, you are allowed to charge it. So we'll have to look at those on a case-by-case basis. Our HOA would like to put a temporary hold on late fees for monthly assessments, but we don't want to advertise it to discourage abuse. Based upon the current environment, would it be okay for the board to approve a temporary change in the executive session? So yes and yes. Kind of along the lines of the previous question, if your board decides that you're going to waive a late fee, that is a decision that can be done in executive session, in my opinion. And, what I would suggest is just that the meeting minutes reflect that you agreed to waive the late fee for this particular owner and why, and just have the meeting minutes reflect that. I know that there are a lot of questions that have come in, during this Facebook Live, and we can't get to all of them right now on the live presentation. And so what we're going to do is we're going to spend the next few days trying to do a response to each one of them in the reply category. And we'll hopefully have all of our responses finished by Friday afternoon so that we can all have a nice weekend. And so continue to look back to the questions that have been posted on Facebook Live. And we'll do our best to respond to all of them by Friday, 5 p.m. So if you had a question and we didn't get to it today, know that we'll do our best to respond before the weekend. I'd like to thank all of you for joining us here today. It looks like we had over 100 people that stayed on for the entire Facebook Live. And I really thank you for caring so much about your communities and wanting to hear more information about how you can help your associations. And we wish you all the best during these difficult times. And I look forward to seeing you all in person, in the future. But until then, we're going to continue doing Facebook Lives to provide good information so that all of you are making, good decisions for your association. So thanks everybody for tuning in today. We'll have more Facebook Lives. We have some really fun and exciting things to announce in the next few weeks that I think will be providing some excellent educational opportunities for boards. So stay tuned and have a wonderful rest of the week and a great weekend, everybody. Thank you.